The topic for discussion is communication suit for cyber agents, section 66A of Information Technology Act 2000. 18 years back in 1995, when in India for the first time internet started, there was no such problem because we are not dependent on internet. But today there are a lot of problems are coming up and we require a lot of research and discussion. And India passed for the first time in 2000 that first Act, IT Act. Because we have to satisfy the international norms, because India signed the National Model Law of 1996, that is for e-commerce. So we generally pass the IT Act just to provide level playing field for e-commerce. But right now we see that a lot of the crimes are committed, and then again violation of human rights are there, violation of privacy is there. So there are a lot of issues. So cyber law, you cannot say one branch of law, one area of law, because it is coming in all areas, whether media law, communication law, or human rights law. All the laws are actually, you can say, nexus between the cyberspace, because we are going to be dependent on cyberspace for e-commerce and for m-commerce and all these things, because it will decide our future. The way we are going to regulate the internet will decide the future growth. If you are going to have a lot of rich regulation, much regulation, it may hamper our growth. If you are going to have very less regulation, it may lead to violation of a lot of rights. So now the question is that we have to discuss and find out what is the actually the way of regulation. What should be the regulation? How much we can regulate and how much we can give free hand. So we have to maintain the growth as well as we have to maintain the rights. Rights should not be violated. We have seen recently on 18th November that one girl might be knowing that Shaheen Dhaba and Runu Srinivasan there posted a message on the Facebook. It has created a lot of debate. So that's why we are talking about 66A, because it was added recently in 2009 and amended the 66 section of the IT Act and added 66A. I am just reading the section and you will find out that this section is giving a lot of problems, because there are a lot of words are there. It requires a lot of discussion and debate, because only Act is mentioning certain words and Act is not mentioned details. What does it mean? I am just reading the section that any person who sends by means of a computer resource or communication device any information that is grossly offensive or has menacing character, or any information which he knows to be false, but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, intimidation, enmity, hatred, or ill will, persistently by making use of such computer resource or communication device, any electronic mail or electronic mail message for the purpose of causing annoyance or inconvenience, or to deceive or to mislead the addressee or recipient about the origin of such message, shall be punished with imprisonment for a term which may extend to 3 years and with fine. If you read this section carefully, you find that there are 11 words are there, and this requires a lot of discussion and clarification. Grossly offensive or menacing character is a very general word. How to find out which word is grossly offensive, which word is not grossly offensive, what is menacing character? Causing annoyance. Annoyance is a very general word. Something may annoy me, something may not annoy you. And what is the guideline, what is the dividing line that which word will be annoying, which word will not be annoying. Then inconvenience, causing danger or obstruction, insult, injury, enmity, hatred, ill will. These words are there. And then again, in the same amendment, what they have done, they amended 77B, and they are saying that all those offences for which liability is 3 years jail, all are cognizable offence. It means that police, without taking the court warrant, now police can file FIR, they can investigate, they can arrest. It means that you are giving sufficient power to the police, that police, even just by seeing all these activities, they can arrest and also they can harass the people. Again, they have amended the 84C. It says that even if somebody is trying to commit an offence, he can be again, police can then again follow same procedure. Police can file FIR, can arrest and investigate. Because how to find out that who was going to commit an offence? Suppose I am having a mobile phone, mobile has internet connection, I am going to somebody obscene message. I may not going to send the message, but some police, they want to harass me, they may arrest me. They simply say he was going to commit a crime. And the punishment is given is half for the same offence provided in the main act. Suppose if the offence regarding hatred is 3 years, if I am going to commit an hatred, my punishment is 1.5 years. So there are a lot of sections which is providing a lot of problem for us. Now then we have to see and discuss, because in the Shine Dhaba case, she posted the message on Facebook after the death of Mr. Bal Thackeray that she was not happy with the shutdown of Bombay. It was just an opinion that why we are going to shut down a commercial capital of India. It is not a good practice. And one friend, she has just liked that message, and both were arrested by the police. If you see CRP section 46 class 4, it says that no lady can be arrested before sunrise, and the police arrested during the after sunset. It means that there are a lot of issues are coming up. It means that police is not able to understand the law, the IT Act. Also, police is not able to follow even CRPC. This means that we have to also train the police persons. So we have to discuss and find out and give clarity to the law. At the same time, we have to also train the police persons, because they are executives, they have to execute the law. We know their qualification, their understanding about the general things. How we can expect the police person to understand the complexity of the IT, internet, and all these things. Then again, in the same amendment 2009, what they have done earlier, the investigation of cyber crime was in the hands of Deputy SP. What they have done, they have now given the power to inspector. Now any inspector rank person, police, he can arrest for violation of any cyber crime. Then it means that we have to train all the inspectors across India and making them understand what is law, and then again they should know what is the technology, and then again they have to investigate. Who can investigate? Only you can investigate if you are expert in the IT. Then you can find out that somebody is going to commit a crime. So there are a lot of issues that are coming up. So I will request all the panelists, they can discuss and find out the ways and means, so we can understand the nuances and complexities, and in future we can suggest the government of India to amend the IT Act, so this Shine Dhaba like is may not happening in future. Thank you all of you. I will request Mr. James Arun. So kindly, because we have the paucity of time, please wind up in 5 minutes.
Good afternoon. At first I was given 10 minutes time. I thought I'll wind it up in 8 minutes and make a record. Now it is 5 minutes. I try to do it in 4 minutes. Blessed is the speaker who speaks short, for he'll be invited again. That's what I believe. All right. I'm an advocate. I practice law in courts. I get people in, I get people out. All right. Depends on which side I am. So 66A is a specific clause in a section in the Information Technology Act, which can be misused by the police or the law enforcement agencies. As an advocate, we can use that section to put some people inside if you want to, and if we are on the defense side, we'll do our best to see that they are not put inside. Right now I'm going to maintain a neutral stand and not do either of that, and just explain to you in my understanding what exactly is 66A of the Information Technology Act in 4 minutes, and try to do a good job about it. Thomas Jefferson, President of the United States, former, said, if a law is unjust, a man is not only right to disobey it, he is obligated to do so. And as a lawyer, I believe, I may disapprove of what you say, but I will protect to my death your right to say it. So this is the right to freedom of speech, which is guaranteed in our Constitution. Everyone thinks free speech is freedom of speech. There is a difference in free speech there's a difference, it is different from freedom of speech. I can stand here and exercise my constitutional given right to speak what I feel, what I am passionate about, or whatever I think is correct according to me, truthful according to me. That is freedom of speech and expression. It does not give me a right to stand here and say whatever I want to say. I can't say, because I am entitled to speak, I can't say words that will hurt any one of you. Whether on the basis of religion, gender, age, color, whatever. That is bad in law. So while Article 19(1)(a) gives us the inalienable right of freedom of speech and expression, the same article, sub-article 2, places something called as reasonable restrictions. Section 66A, according to me, is a reasonable restriction on anyone who accesses a computer or a computer resource, a computer system, which is basically your cell phone. Everyone has a cell phone in this room, I presume. So the fear of 66A, I want to remove it today by telling you actual position of law. I think I'm done with 2 minutes. In 2 minutes I'll finish it.
Give us your appointment book. We want to call you soon.
Oh yes, I'm going to tell that last. My friend here has spoken to you and told you about section 66A. Download it from the internet, read it. It's not a complicated thing. IT Act you can download and go through it. If you are making notes, any one of you, I will say 66A is something that you should note. 77B, note that. That says that section 66A is non-cognizable. That means a police officer without a warrant from a magistrate cannot arrest you when you send out an email or post a blog or make a posting in the Facebook or create a website, and it is totally bailable. That means the moment the police officer arrests you, in case they do, under this section and only this section, you can be bailed out immediately on your own or by a lawyer like me or by your parents or by your friends. Anyone can bail you out. It is also compoundable. That means if you have done something really bad and you messed up, don't worry, you don't need to go to jail. If you speak nicely to the judge, they can compound it. That means you can pay money and get out of it. So this section 66A is non-cognizable, bailable, and compoundable. But you know, the policemen are tools of the state. So if you have a politician who is strong and if you have somebody who wants to put pressure on these poor police guys, they will arrest you, they will harass you, they will do whatever they can for 24 hours before they produce you in front of a magistrate. So in case something like that happens, please put a good lawyer on your speed dial, on your phone book. The moment somebody calls you saying that they're calling from the station, call us, we'll help you out. I think my 4 minutes are up. I'll just end with section 66A is a new law. It is evolving. It's a very new law. And as with any new law, there will be clarifications, confusions. So today I think the society in India generally is going through that. And currently there is a public interest litigation pending in the Honorable Supreme Court of India, wherein I'm sure in the coming few months, the law will be explained clearly. The Supreme Court will make appropriate guidelines what a policeman can do and cannot do. So until that time, you guys be patient. I'm sure you will find more clarity in the law sometime soon. But as of now, this is the legal position. Policemen, if they mix this section with any other section which is cognizable, then that would be a ground for arrest, but not under section 66A. It could be something else. Defamation, criminal intimidation through anonymous means, murder, attempt to murder, homicide not amounting to murder but with connected to 66A. So it could be any number of things. So right now, don't get too confused about all this. Just keep a good lawyer's number with you on your cell phone in case you get into any problem. Call us, we are more proficient in it, in handling it. You are all media guys. When you are doing something, just remember, be truthful, be honest, and as long as you believe it is right, please go ahead and exercise your constitutionally given right to free speech, and we will protect you from behind. Thank you.
Abhi, to please make his presentation.
Thank you, Mr. Kabir, and good afternoon or good evening, my friends. Now, one thing I would like to say is, of course, whatever presentation I wanted to make today will be available on my site, navi.org by tonight.